So there's a pretty big update today in the Courtney Clenney case. If we look at the docket, we see case closed today. This is for the laptop case where Courtney Clenney, her mom, and her dad were all charged with unauthorized access. This is in reference to a laptop that Courtney's dad had recovered from the apartment that belonged to Christian Obumseli. And they had gone in it, looked at the passwords, and the state prosecutors ended up finding this out and seeing some of their group chat messages. In response to that, both Frank Prieto and Sabrina Puglisi challenged this as an attorney-client privilege violation. And then additionally, when Jude Facadomo and Tara Kawas jumped on to help defend in this laptop case, they argued the same. So there's been a lot of hearings and a lot of delays for this. It looks like the homicide case won't happen until 2025 at this point. But today we're getting this big whopper of a news that the state chose to drop charges for this laptop access. And you can see the disposition here. So this is against all three of the Clenneys, and it's really nolly prosequi. So, and I've got to do a panel with some lawyers, get them all together. We can go over pronunciations. But what that means is the state has chosen not to prosecute. That's the reason that this is closing. It's not because the defense had filed this motion to dismiss, which they did, and then the judge ruled, yes, I'm going to dismiss this. It was a state that came in and said, you know what, we're not going to charge this. We're dropping these charges. So we're not going to prosecute. That is the official disposition here. And you can look back and see a bit of the timeline here. So back on the previous hearing on June 26th, this is when Judge Laura Cruz made her order. She said, look, we're going to exclude, we're going to grant this motion to exclude some of this evidence that was the subject at the center of this attorney-client privilege violation. So we're going to suppress this evidence. It can't come in. And if that evidence can't come in, well, then we don't have the evidence of those communications that, oh, that one worked, that password worked. We covered that back in February and March. But if that stuff can't come in, what's the evidence for these charges to stick? So charges are now dropped. And that might not be the case, you guys, if there wasn't a violation of attorney-client privilege. We're going to get some more context on that, but before we switch over to an article sent over by Ann Stuff, so shout out to them, I do just want to look at the remaining case, the homicide case. If you've followed along on this channel, you've heard me talk about how this interception of wire communications charge was added in February at the same time these unauthorized access laptop charges came into play. This is still currently standing. However, there is a status hearing in this case for August 13th. So I'm personally curious to see, does this still stick? Did this come about because of something that was suppressed because of an attorney-client privilege violation in the other case? If this charge stems from the same thing, it's possible that we could see this charge go too. This could become something that's off the table in the future.
How might this affect the homicide case? So kind of big picture, we know that is, of course, the most important case for your client, Courtney. What does this ruling do, if anything, in that case?
Well, I think one thing it does do is it gives us even better opportunity to have these prosecutors removed from the case. We've said all along they're not following the rules properly, this win at all cost mentality. We finally, I think, are going to be able to get them off the case. We are going to absolutely move to recuse them.
And then let's round this up with some coverage from the Miami Herald. So this is from David Goodhue. State drops computer hacking charges against the parents and daughter in OnlyFans model murder case. And you can see bright and early this morning, and Stuff sent it over right away. So state prosecutors dropped the computer hacking charge Thursday against the parents of OnlyFans model Courtney Clenney and of Clenney herself, who's accused of stabbing her cryptocurrency trader boyfriend to death in a Miami condo in 2022. And this is really what it comes down to, you guys. The decision comes down after Circuit Judge Laura Sharon Cruz last month ruled that the Miami-Dade State Attorney's Office violated attorney-client privilege. They did this when prosecutors confiscated text messages and emails between Deborah Lynn and Kim Dwayne Clenney, their daughter and her attorneys, back in January of this year. Sharon Cruz granted the Clenneys' attorney's motion to exclude the messages in the hacking case because their daughter's lawyers were also representing them at the time, and the state violated attorney-client privilege. Clenny's lawyer, Jude Facadomo, argued that prosecutors' actions demanded a full dismissal of the charges against his client because it's misconduct. It's misconduct. So there's a quote here from Facadomo that says, "It's a bedrock principle of privacy the state should never have breached. They entered the defense camp," Facadomo said. "All of that taints their prosecution. They targeted our clients, Kim and Deborah, for no reason." And if you didn't follow along to this arrest warrant and laptop saga, this is really the context. The more than 4,000 messages were collected during a January raid on the Clenneys' Austin, Texas home after a judge signed a warrant giving investigators access to an iCloud account. And that iCloud account stored communications between Courtney Clenney, her parents, and her attorneys. Frank, they spelled this wrong, there's an R missing, but Frank Prieto and Sabrina Puglisi. And this article is going to focus on one of the reasons, but really prosecution made two arguments against the motion to dismiss these laptop charges. The one was, hey, we didn't violate attorney-client privilege because we didn't know Deborah and Kim Clenney had attorneys at the time that this warrant was obtained, since they were not charged with a crime. But we found out through testimony, and you can go back and watch the second half of that hearing on my channel. I'll link it in the description. They didn't inquire. They didn't try to find out. And there's an additional layer because even if they hadn't been representing Kim and Deborah in any capacity, attorney-client privilege can protect, can extend a conversation that's meant to be confident and in the furtherance of the client's defense, meaning Courtney's defense. So the defense had offered a counter argument to that point. But additionally, and they don't show it here, but prosecutors tried to make a second argument to defend themselves. They said, look, these messages were exchanged in furtherance of a crime. Therefore, the attorney-client privilege, there's an exception to it. We have the right to see it because they were committing a crime. And Judge Laura Cruz was like, well, what crime were they committing? And they couldn't prove their case. They couldn't make their argument. So again, going back to where this case goes from here, we have a status hearing on August 13th. And they always schedule it for weird times, 9:38. Not all of them have camera access, you guys. I don't think the news stations are going in for some of these, even though these are some major developments. You'll actually see that the only record, the only remaining stream online from one of the previous hearings, I think that was either May 14th or maybe it was back in April, is a really crappy bitrate, bad bandwidth stream that was recorded through us live streaming it. But there were really some fiery arguments. Frank Prieto had to get on the stand, just a lot of crazy stuff happening. So this is where we're at. I don't think we see much impact to this here. However, I'm curious to see if we get an update on this since it seems to be related to the same thing that spawned the laptop charges, which is now the state has dropped those charges. And it looks like this trial 2025, you guys. So let me know your thoughts, you guys. You don't mind if you've paid attention to this channel, even if it's not for this case specifically. If someone's guilty, that still doesn't make prosecutorial misconduct okay. And you've heard me make my arguments and give my reasoning why I don't believe, at this point in time, unless I have new information, why I don't believe that Courtney Clenney will be able to make her case that this was a justifiable use of force, that this was truly self-defense. I don't believe a jury will buy into that theory based on the evidence I'm aware of. However, at the exact same time, I'm not okay with the state being able to violate attorney-client privilege. And there's been some other rumblings of prosecutorial misconduct with prosecutors in the same office, the Miami-Dade State Attorney's Office. And it looks like they're trying to make some changes to correct that and do better. And I hope that they do, because this is what happens when they don't. So you guys let me know your thoughts. All thoughts are welcome. You guys all take care until next time. Bye.